Everyone see that? Do you see just the slideshow or everything?
I can see you and the slideshow.
Okay, but you don't see the slides at the bottom, the preview and stuff? Okay.
We're good, Deb.
All right, good morning. Thank you for joining us this morning. I am Deb Newman, President and CEO of the Bangor Region Chamber of Commerce. Shelley Sun joins us. She is our Director of Marketing and Events. And we are delighted to be here with Eaton Peabody talking about legal questions every small business startup should ask. I first want to acknowledge Eaton Peabody for being our early bird breakfast sponsor for years now, both in person and virtual. This isn't as early bird as usual. We will be returning to in-person early bird events this fall. Can't wait. There will be bacon finally. But in the meantime, we're grateful to Eaton Peabody for your support and the legal team joining us this morning to talk about everything you as a small business needs to know, as a startup needs to know, any legal questions. We are recording this event. We know that it's vacation time, and there are some people who wanted to join us who are not able to join us. So this will be available on our Facebook page. If you have questions as we go through the presentation this morning, you can ask your questions through the Q&A, or if you're joining us live on Facebook, you can post a question in the comment or just send a message, and we will make sure that we answer your questions this morning. Fortunately, we have legal experts joining us who have the answers that we don't. Joining us, we have Johanna Colpritt, Katherine Porter, and Rebecca LaPierre. All of our presenters are experts in any aspects of employment law, business law, and have, again, good information to share with us this morning. Nate Levesque also joins us as well. So thank you to all of you for being here. And we'll go ahead and get started. So I will turn it over to our great team joining us here from Eaton Peabody.
Great, thank you so much. So my name is Johanna Colpritt, and I'm a business associate at Eaton Peabody. And I have some pretty large topics to cover today, but I'm going to do my best to cover each one. It's going to be the basics. So if you have any follow-up questions, please feel free to reach out either through the chat or thereafter. I'm happy to chat by email as well. So for those of you who are wondering, the first question is, where do you start, right? So you may be at the point where you have decided that you want to turn, perhaps it's a hobby right now, into a business. Or maybe it's always been your lifelong dream to start a business, or maybe you've even been at it for a year and you're just wondering, okay, what's that next step? So this will cover, all of those things, just this initial phase of a business. And the first thing I recommend that you do is a business plan. So I would do this before I even go to an attorney. Of course, that's your decision, but I think that this is the opportunity to sit down either with yourself or your partners, whoever you're working with, and say, okay, what is the purpose of my business? And by purpose, I mean, what's the mission? What do we want to resolve? What do we want to do? What do we want to see? The goal, very similar. Do we want to grow the business and eventually sell it? Do we want to stay local and be kind of a mom and pop shop? Do we want to seek partners with other businesses? Related to that, who's going to be involved? Is this a business that's going to be run primarily by you? Are you going to have family involved? Are you going to have friends involved? Do you have third parties involved? And of course, how are you going to fund the business, right? Where's the money going to come from? Do you have the capital at the outset, or do you need to go seek money, whether that be from a bank, from family and friends, from outside investors? And then your timeline. And the timeline, remain flexible, because that's always going to change. I think that people start sometimes and they think that you're going to get all of this done right away, but things take time, especially if you want to do it right. And I highly, highly recommend that you do things right the first time. And so one other thing that I would do probably before seeking an attorney is using these other resources that Maine has to offer. These are just a few of them. I apologize to those who I have not listed here. There are many others. But these are organizations that offer either free or low-cost services. They have websites with lots of resources and tools on them. They have people that are there daily to help you get started. They, if they can help you, they usually have the connections to connect you with someone, whether that be a mentor, other attorneys, other service providers. And this is just a really great place to start, are these organizations in terms of remaining cost efficient and effective. So now it's probably time for an attorney at this point, right? You have your business plan, you've used those other resources. Now you're going to go find someone that's going to help you with this next step. And the next step is deciding what type of entity you want to form. So I'm going to talk about the 4 primary types. There are variations within these, but the 4 primary types are a sole proprietorship, a partnership, which there are different variations of, an LLC, which is short for a limited liability company, or a C corporation. And Nate, if you want to go ahead and go to the next, oh, there we go. Yeah, it's one of those. All right. So we're going to go ahead to the next slide. And on the next slide, this is a summary of what I'm about to describe to you. So I like to look at these entity types in 4 categories. So 1, how do I form the business? What is going to be my liability once the business is formed? How is my business going to be taxed? And what are my options for financing and funding my business? So I'm just going to touch upon the sole proprietor and the partnership because we don't see those very often. But I think there are a couple of points I want to highlight. So many of you have probably been a sole proprietor at one time. I know I have. As a child, if you were running a lemonade stand out in your neighborhood, you were a sole proprietor. A sole proprietor doesn't require any type of filing with the Secretary of State. It doesn't require any formal documentation. It's just you out there running a business, and that's all it takes. And similar to that is a partnership, or at least a general partnership. So if you're out there in the neighborhood, you and your friend, and you're running a lemonade stand and you're selling to customers in the neighborhood, you formed a general partnership. And so with a general partnership, the one thing I want to highlight on this is you need to be really careful, because if you are operating as a business with another partner, you are going to be jointly and severally liable for those partners' actions. So that's something to keep in mind. If you start, say you're just, okay, I'm just going to get my business up and running and we're just going to run it as a partnership right now. We're not going to get attorneys involved. We're not going to have agreements in place. You need to be really, really careful about that. And I would actually discourage doing so. So now what I want to spend most of the time highlighting is an LLC and a C Corp. So an LLC, in the grand scheme of all corporate law, is a relatively new concept. And it's very, very common now because it affords the best of all of these other 3 options. So the formation is relatively straightforward. I like to think of it as 3 steps. 1, you file what's called a certificate of formation with the Secretary of State. 2, you get an EIN for your business, meaning your employer identification number. And then you have an LLC agreement, which for those of you who are more familiar with corporations, it's synonymous with bylaws. So it's just a governing document. And with an LLC, the great thing is that you have the limited liability of a corporation. So what that means is an LLC is an entity and it's a person under the law on its own. It will be liable for all of its own obligations that arise. So your personal assets are protected. That's one of the best things about an LLC. And then the second great thing about LLC is the taxation piece. You have the option. So as an LLC, what you refer to the owners as members, and you can either be taxed as what we call a pass-through entity, which means that all of the profits loss flow through from the business to the members' personal tax returns. Or you can elect to be taxed as a C corporation. meaning that the LLC will be taxed at whatever the corporate tax rate is. So that's a great thing. I always recommend that folks talk to their accountant or CPA about this ahead of time, plan ahead. We certainly can advise in certain aspects, but you want to get an accountant involved as well. And then I'll touch upon the financing in the next couple of slides, but as a C corporation, this is what you probably traditionally think of when you think of corporate law and businesses in general. Formation is relatively similar. You're going to file articles of incorporation, or they might be called something, a variation of that, depending on the state that you form in. You're going to, again, get an EIN for your business with the IRS, and you're going to have bylaws in place, which is your governing documents. It's how you operate the business. It's, what are the officer roles going to be? Is there going to be a board of directors? Are the shareholders, meaning the owners, going to manage the business? Again, similar to an LLC, you have that limited liability. A corporation is its own person under the law, and it will be liable for its own obligations. And then taxation, you don't have the flexibility that an LLC offers. You will be taxed at the corporate rate at that time. So with a C Corp, the important thing to note is that the corporation itself will be taxed at whatever the corporate rate is. And then whenever the corporation is going to distribute dividends, meaning whatever is left over and they're going to distribute it to its shareholders, then the shareholders will also be taxed when they receive dividends. And so you may be wondering, what about S Corps? My friends have talked about this, or my colleagues, or whoever else. S Corp is an option, although an S corporation is not an entity type in itself. I like to just distinguish that. So how an S Corp works is you actually form an LLC or C corporation at first, as I described in the previous slide. And then what you do is you make a tax election with the IRS. I believe it's form 2553, and you will file that, and then you will be taxed as an S corporation. Again, you're going to want to talk to an attorney and or an accountant or CPA about this, because there are certain requirements that the IRS has imposed in terms of what kinds of shareholders you can have, how many shareholders you can have, etc. So now, where are you getting the money to fund this business, right? So again, this is the basics. So I'm going to look at this in two different options. So one, you have debt financing, which I think for most of you is probably your traditional concept of financing a business. It's loans. So loans can come in different forms. It might be a loan that you receive from a family member or a friend. It might be a loan that you get from a bank, so a traditional loan, or it could be convertible notes, which is a very similar concept. You might have investors and they are going to contribute money to your business with the expectation that depending on whatever the terms are, that may convert the money, the loan that they're giving you may convert to equity in your business, depending upon circumstances. So with loans, typical terms are involved. You'll have installment payments, meaning you may be paying probably typically monthly, perhaps bi-monthly, yearly, whatever it may be. It'll be for a fixed period of time, year, 5 years, 10 years, etc. And there's typically interest involved. And there are, of course, advantages and disadvantages to both. So some of the advantages are that you're receiving money and you're not giving up any ownership in your business, which is great for a lot of people. They don't know, they're just starting their business. Their idea is that they're either going to be 100% owner, they're going to be 50-50 with a partner. With a loan, you're not giving up any of that ownership to someone else. You're also not giving up any control. So in terms of day-to-day management or even a broader level of oversight, with a loan, typically people aren't getting any kinds of those rights. Again, a loan is for a fixed period of time. So once that time is up and you've paid off your dues, the obligation is done and you can clear your hands of that loan. And then, of course, there are some disadvantages to a loan. So you do need to repay it. Sometimes startups aren't as successful as they hope to be, or maybe they're not in the short period of time. That obligation isn't going anywhere. So you're still going to be obligated to pay that loan back. And then with startups specifically, if there's not a long operating history, then whoever is giving you the loan, they may require personal guarantees on that loan, which is something that you'll need to consider. You know, how much exposure do you want for your personal assets? And the terms may be subject to change. That depends on the loan, it depends on your lender, but something to consider. The second option of financing is equity financing. And equity financing is when you're receiving money in exchange for giving up a piece of ownership of your business. So again, this can come in different forms. You may have started a business originally, but you realize that you want to bring in this particular friend who happens to have a lot of capital, and they're going to come in and they're going to give you $100,000 to your business, but they want 50% ownership. So that would be, you know, an equity exchange. You could do equity fundraising, which is what we do a lot at Eaton Peabody. And that would be through angel investors, which there are several groups in Maine that are very committed to the startup and, you know, emerging company community. So you can seek out those. Venture capitalists, similar concept. And then a new form of fundraising is also crowdfunding. So that's an option as well. And, you know, again, advantages, disadvantages to equity financing. With equity financing, you're typically, this is a general statement, you might have the opportunity to raise a larger amount of money from investors, and that gives you the ability to scale and grow your company much, much quicker. And another really big benefit of doing the equity financing option is, although you are giving up some ownership to investors, these investors typically have very valuable experience. So they may have experience in marketing, they may have experience in finance, they may have connections, whether it's inside the state or outside the state, operational experience, whatever it may be. An investor is typically going to be providing some level of oversight in day-to-day, not day-to-day, but some form of management and be involved in the business. And that can be really valuable. You know, the disadvantages, some of them are relatively obvious. I've mentioned them. You are losing some control over your business. You are losing some ownership over your business. And it can be costly and somewhat time consuming. If you're going to do equity financing, you want to have an attorney involved. There are several documents that need to be drafted, and you'll want the business to be represented accordingly. So there will be, you know, typically attorney's fees. So something to keep in mind, depending on what stage you're at and whether you want to seek out this option of financing. So now I'm going to run through very quickly, trying to pay attention to time here, the basics of intellectual property. And I will just say that I'm not an intellectual property expert, but these are just some basics that you will want to keep in mind when you're starting your business. A lot of things to keep in mind with intellectual property is the timing, because there are certain filings that you can make with applicable offices that will benefit your business tremendously. So just to back up just for a moment, a business typically has 3 different types of property. So you'll have real property, which is your parking lots, your business, your buildings, things like that. You'll have your personal property, which is things like furniture, equipment, computers, inventory, and then you'll have your intellectual property. And that's things like your brand or your processes or your recipes or your formulas, things like that, things that you can't touch or feel. And so I think sometimes people, they forget about that. But intellectual property is increasingly one of the most valuable assets a business can have. So, like I said, there are 4 different types of of intellectual property that I'll discuss. The first being trademarks. So your trademark is your brand. It can be your brand represented by a symbol, by a name, by a phrase. I think it's helpful to think about trademarks in terms of examples. So an example would be the Nike swoosh. And another example would be when you see the golden arches for McDonald's, you immediately know that's McDonald's. Those are examples of symbols. You can also have a name that can be a trademark. So when you hear the name George Foreman, you immediately think of grills. That's another example. You can also have a phrase. So when you hear taste the rainbow, you think of Skittles. or when you hear the world runs on, America, or excuse me, whatever it is, runs on Dunkin', right? You think of Dunkin' Donuts. So I think when you think of those examples, it becomes pretty obvious how important and valuable trademarks can be. And how you protect trademarks is you use it. So you make sure that everyone else is aware of what your trademark is. And you can also register your trademark, which we would highly recommend. Registering it allows you the exclusive right to use your trademark across the nation in connection with whatever your service and or good is. And then a lot of times you'll see, so the little C with a circle in it above certain things, that's for copyright. Trademarks have a similar one, little R. And I think that when people see that symbol above a trademark, it deters them from infringing upon it. And the last thing I'll say about trademarks, which is probably one of the most important things, is when you are developing your trademark, you're thinking about what you want that phrase or that mark or that symbol to be. You want to take a look at this chart down below. And I think of it between descriptive versus distinctive. So you do not want your trademark to be descriptive. For example, the generic ones over here, log cabin homes, that's literal. It's a factual statement that might be what your product is, but it's not going to be able to be trademarked. It's too generic. As opposed to when you look at the arbitrary and the fanciful categories up here. Arbitrary, for instance, is when a word did previously exist, it has its own meaning, but a company has taken that word and has associated it with a different meaning now. So Apple, not necessarily the fruit anymore. A lot of times people associate that with phones or computers. Similarly, Greyhound, a type of dog, now it's associated with buses. And then fanciful is the best you can get. And those are words that did not exist before the business created them. So Nike was not a word that has no other meaning other than the business, which now we think of Nike, we associate it with athletic clothing or sneakers. So make sure you're being distinct and not descriptive. The next type of intellectual property I will talk about are patents. And so patents are a right that's granted to an inventor, and it's for a limited time. And it excludes others from either making, offering, using whatever that invention is, and as well as protecting it from being imported from other locations into the US. So a patent, it needs to be three things. It needs to be useful for whatever the specific purpose is. It needs to be novel, meaning it needs to be original, and it needs to be non-obvious. So it can't be an obvious, perhaps, substitution from something that's already an invention that's already been patented, and just a minor tweak is made to it. That won't be able to get patent protection. There are different types of patents. So the most common are utility patents, which also includes business method patents. This is, machines or chemical and biological compositions or certain business software processes. Those are the most obvious. Once registered, they typically have a 20-year protection. You can also have design patents. So design patents are ornamental designs of manufactured articles. So for example, an iPhone case perhaps, or the hood of a car. And design patents typically have a 15-year protection. So the critical thing to keep in mind with patents are the dates. So the first person to file for protection receives the rights, and you need to file within 1 year of the invention being publicly disclosed. The third type of intellectual property I will discuss are copyrights. So copyrights, it's a protection for original works of authorship that are fixed in any tangible medium of expression. And you might be thinking, okay, what does that mean, right? So it is original in that it was created by an author or authors, and it was minimally creative. And over here on the side, you can see some different types of categories of things that can have copyright protection. So within literary works, for example, you think of books or publications or manuscripts or magazines. In dramatic works, you might think about screenplays, And then in the graphic and sculptural works, you can consider that maps or plans or other things like that. So the thing with copyright is you also want to file for that, although things do receive copyright protection as soon as they are created. However, the reason that we recommend you file for copyright protection is because if someone were to infringe upon your copyright, it affords you an additional level of protection if you're going to bring an action. And it also enables you, if you are going to bring an action, to hopefully seek attorney fees and other forms of damages that you may not otherwise be able to seek. And what else I want to say about, so copyrights. An important thing with copyrights is you may be hiring employees as a business, or you may be hiring independent contractors, and they may be developing these things that have copyright protection ability. So if that's the case, again, you want an attorney involved because you're going to want certain agreements in place, whether that be assignment agreements or agreements that specifically outline what the scope of the purpose of that employment is, so that when these works are created, they're going to be the ownership of the company and not that of the employee or the independent contractor. Very important to remember that. And the final piece of intellectual property I will touch upon are trade secrets. And trade secrets are different types of information, maybe business information, financial information, technical information that is not known to others. And they are specifically valuable because they are not known to others. And thirdly, there are reasonable efforts put in place to maintain that secrecy. So trade secrets are a little bit different from the other three that we just talked about, because you don't file anything to protect them. You simply keep the secret. So again, examples are helpful when you're thinking about trade secrets. You might think of the recipe for Coca-Cola's soda, or the recipe for KFC's fried chicken, or Adobe's, the software that Adobe has for its Photoshop. Those are all trade secrets. They're not known to others. And because they are secret, they are very valuable from an economic perspective. So before I hand it over, I just want to touch upon a few key points. Plan early. As I said, get your business plan in place. Use those free/low cost services, and then seek an attorney so that we can have a timeline put in place for you and everything can be done correctly. And yeah, so with that being said, I will hand it over to my colleagues.
Johanna, can I interrupt with a couple of questions?
Of course, yeah.
This was great. Thank you so much. One question I had that I've heard from startups is, can you change the formation of your entity later?
Yes. So we would just call that converting your entity, basically. And we see that a lot of times. Sometimes people will form perhaps a partnership or an LLC, and then they realize they want to bring on outside investors like angel investors or venture capitalists. And a lot of times those types of folks, they're going to require corporations because there's more protection and structure. So we'll convert it. And that's a matter of some filings, changing your corporate documents. But yes, that can be done.
Okay, thank you. And the second question came in, where do I get a copyright?
In terms of where do you file, there's the US Copyright Office, and beyond that, it's just a matter of creating the work and doing the appropriate filing.
Okay, great. This was, and I've got a few more questions, but I'll save them till later if they're not,
okay,
addressed. So thank you so much.
Yeah, thank you.
Right. Well, thanks, Hannah. My name is Katherine Porter, Katherine Porter, and I'm an employment attorney with Eaton Peabody. I work with Hannah often on corporate transactions, and I work with Rebecca all the time on employment matters. So we definitely both do litigation, but we do a lot of corporate work and advising our clients, specifically at Eaton Peabody, a lot of startups, which is a real pleasure to get on the ground floor with really interesting companies. So, let's go through a couple of the topics we're going to discuss today. So as a startup, you've formed your business, you've consulted with Hannah. You also have thought about your IP. The next question is, all right, we got to get this business rolling and we need people to do that. So who are you working with? What are the classification of your workers? Should you document that relationship in some way? Do you need HR? Do you need counsel to advise you on HR matters? And one of those issues you're going to think about are what notices do we need to post? Do we need to have employee handbooks or policies in place to govern these workers? And one policy that we all are very familiar with is telework. So we're going to talk a little bit about the advantages and concerns with those policies. And then we're going to touch briefly upon employee benefits. It's not specifically my area or Becca's area, but we do have colleagues that specialize in employment benefits. And it is something that we just want to flag for startups, something to think about. So next slide. Classification of workers. This is very important. It's one of the first questions that I ask clients when we are meeting for the first time is who do you work with? Tell me about them. And what I'm getting at when I ask that question is I'm trying to understand how they're classified and if they're misclassified. Because to the extent that we can classify them properly from the outset, that's great. That means you're going to avoid a lot of liability and streamline the process for your company. If they are misclassified, we will reclassify them as soon as possible to limit damages and liability. So the first category really is, are you classifying workers as employees or independent contractors? And what that question boils down to is really a question of control and degree of control. So generally you think of employees, they are their time, their hours of work, what they're paid, what they do, when they work. All of that is really set by the employer. Obviously, there's a dialogue often, but the employer decides ultimately how the work is structured. They're under a high degree of control. Independent contractors, you often think of them as sometimes having their own business, maybe not, just working for themselves, but they usually have a specific type of work that they are marketing to employers, whether or not that's bookkeeping or something else. They sometimes have their own employees, and generally they'll do the work that you ask them to do, but they have more control over when it's done and exactly how it's done. So in the state of Maine, we actually do have a statutory test, and we've set that out here. And we can circulate these slides so you can all see it. It's actually a longer test, but the first part of that test is under Section A. And to be an independent contractor, you must satisfy all of those criteria. So all 5 prongs of that test. Once you satisfy those 5 prongs, you then have a second hurdle, which is under B, right there it is. You have to satisfy 3 of those 7 criteria to be properly considered an independent contractor. And you'll see as you go through those prongs that it really comes down to control and how independent you are from the business that you're working with. So it's a high standard, and it's really something that is fact-based. And so, sometimes someone will tell you, oh, I've always worked as an independent contractor in the past, but you really should have counsel work through that question with you to determine whether or not that person should really be properly classified as an employee as opposed to a contractor. So let's assume that you have properly classified someone as an employee. The next question is, should they be classified as a non-exempt employee or an exempt employee? Now, non-exempt employees are those individuals who should be paid time and a half or overtime for every hour worked in excess of 40 hours in a work week. And generally, to make sure that you're protecting yourself from wage claims down the road, we would advise our clients to track those employees' hours. So that should be something that you expect the employee to do, and you communicate that to them through policies and their employment agreement, but also that you as an employer are on top of weekly. If you are an exempt employee, that means that you qualify for one of the exemptions under the overtime laws, state and federal, for someone to not be eligible for overtime. So there's really 2 criteria to that, or main criteria. First is that they earn the salary basis, and that's going to be the higher of the state or the federal salary basis. Now in Maine, we actually have a slightly higher salary basis than the federal standard, and that's $36,000 a year. So someone has to earn that amount per year to qualify as exempt. That's the first standard you need to meet. The second is duties. So you need to qualify for one of the state or federal. There's 2 standards. They usually mirror each other. One of the exemptions. So that could be for professional employees, computer professionals, executives, and also what really comes down, we have issues with often, is the administrative exemption. And the administrative exemption really boils down to a duties test. That person needs to exercise independent discretion and judgment over matters of significance in the execution of their duties. So what that means is that they are able to, they're maybe not the top executive or the chief marketing officer, but they do have duties that they can run with and execute without always having to have them rubber stamped by managers. So again, job titles, it's not going to be determinative of the exempt duties standard. You really should consult with an attorney or someone who understands these issues because it's very fact specific. And we do have a lot of clients that run into issues with misclassification of folks as exempt versus non-exempt. So the other issue that I run into often with our startup clients and businesses in general is, talking about interns. And oftentimes, many of us in the past have had unpaid internships, but that really shouldn't be the standard. It's not. If you are an intern and you are copying papers, doing something that if you weren't there, an employee would otherwise do, you should be paid for that work. That's work for hire, and you should be paid as a non-exempt employee, a temporary employee, but an employee, at least the minimum wage and overtime for hours worked in excess of 40 in a work week. So really, there's a limited exception to that under the wage laws, and that's if you could qualify as a trainee. It's a very high standard. Again, fact specific like all of this, but basically you have to generally be receiving educational credit for the internship and observing more than contributing to the business. So it's a high standard. Again, if you are having an intern work for you and they are receiving educational credit, I wouldn't rely just on that. I would consult with counsel to make sure that you're properly classifying them as an intern as opposed to an employee. So what's the importance of all of this? Well, it's really important because our startup clients are, as Hannah described, often seeking outside investments. Also, if you're not a startup, you're a small business and you're getting ready to, enter into some sort of transaction where you're acquired. These issues are going to come up in diligence, and they come up all the time when we advise on transactions. And, investors and buyers are always asking about classification of employees, whether or not things are documented. And so it's really great when we can say that we've thought about this, we've analyzed it, and we've advised the client, and things are all in order. Because the liability associated with misclassification, it's significant. You could have tax liability. Let's say you misclassify an independent contractor as an employee. Well, you should have been paying withholding taxes and paying into certain tax pools for them. So that's a potential liability. Also, there's wage liability. If you have unpaid wages because you classified someone as exempt, they should have been non-exempt and were working a lot, so they maybe had a lot of overtime. Number one, you're not going to maybe have records of how many hours they worked, so that becomes a major issue. Then there's also in unpaid wage claims, treble damages. That's triple times the wages, unpaid wages, pardon me. And there's also attorney's fees. So the bill gets quite high very quick. And then you also have benefits issues. If you were working with an independent contractor and they really should have been an employee, maybe based on the number of hours they worked, they should have qualified for your benefit plans. You could have issues there as well. And finally, you could have investigations by governmental agencies, which is a complete distraction from the business. And this has happened in the past where I've had someone who, one of our clients had classified as an independent contractor. Maybe, the engagement ended, they went to the Department of Labor and applied for unemployment. Generally, the Department of Labor will ask for any contracts that they had with the business. And if they find out they were a contractor, but it doesn't seem like they should have been, you could have an issue with an investigation from the Department of Labor, for example. So it's all a distraction. We're here to help you guys get back to business and avoid employee issues. So that's why classification is really important. So moving on to, you've classified your workers. Now, what do? Do you document that relationship? And I really think that you should. And again, this touches on if you have an acquisition in the horizon or you're looking for investor seed funding, this is going to be important in the diligence. They're going to ask to see all employment agreements, all consulting agreements, all agreements with interns, and any separate restrictive covenant agreement should you have that in a separate document. So that's going to be important, and they may insist that you put those into place if you don't have them already signed up with those workers. So things I would look for with an employment agreement: you want to have an at-will disclaimer generally. That is the de facto relationship between employees and employers in the state of Maine and many other states. That just means that either party in the relationship can terminate their employment at any time for any reason. Sometimes you will have employment agreements where there's a specific term of employment. That will happen if you really want to have someone who's a key employee in place for a certain period of time, but you again want to have counsel involved in drafting that, because there's a lot of provisions that are important. For example, you may want to, as the business, terminate or reserve the right to terminate that person early and not have to pay them out any money if they engage in fraud, for example. So very important to have counsel advise you on that sort of agreement. So beyond at will or term, you want to set forth the compensation, avoid disputes, have it in writing. And so you want to say what their salary is, if they're paid on a salary basis, how often they're paid, are they paid hourly? If so, what's the rate? And advise them to track their hours. You'll be working with them on that. Is there a bonus? Is it discretionary? If so, let's say that. If it's guaranteed, what happens if they resign or you terminate them because you're not happy with their work? We want to be specific and draft with all of that in mind. Then you also want to think about the choice of law, and this is super important. And I've run into this time and time again. Startups now in this new day and age, we can hire from anywhere in the country. And so you may have an employee who's working generally out of California, but comes to the main office occasionally when asked. Actually, under California statute, you cannot include choice of law that's of Maine, for example. It has to be California choice of law, subject to some narrow exceptions, but that's, of course, very nuanced and important. Also, the choice of law is going to impact the sorts of restrictive covenants that you can impose. So for example, if you have a California employee, again, you cannot impose generally a non-competition restriction on them. Non-solicitation is also not available for employees who work in California. For Maine employees, right? Let's say someone's working in or from generally New Hampshire, but you're a Maine company. Do you want to impose Maine law? If you have a non-compete restriction, maybe not. And the reason why is because if that person's working in New Hampshire, they would not be otherwise subject to Maine's new non-compete law, which imposes restrictions on who you can have non-competes with, notice requirements, waiting periods before the non-compete restriction can kick in and be enforceable. So definitely choice of law, although it seems like a throwaway provision, super duper important. And then finally, this is maybe the most important information you want to include in an employment agreement, and that is the restrictive covenants. So generally for all clients, we're going to see confidentiality restrictions. You want to keep your information confidential, subject to certain carve-outs, which you may have to have in certain industries. Then you also want to have intellectual property, and Hannah touched on this. That's your secret sauce. You want to protect it, and you want to have in writing that the employee acknowledges they have that obligation. Then you also oftentimes will have non-solicitation restrictions. So that's protecting your employees, your independent contractors. Also, you'll have non-solicitation of clients and potential clients oftentimes. So very important to get counsel involved to draft that, so it's exactly what you need to protect your business and your goodwill, but is not overly broad so that it's not enforceable. And then, as I touched on just a few moments ago, you often will have requests for non-competition. And non-competition provisions are definitely under increased scrutiny in the states and federally now. Many more statutes are governing them. In Maine, we have a statute. California, they're prohibited. So definitely something you want to consult with counsel on before including in a contract. But we do see it often with startup companies and smaller businesses. So then if you have a consultant, do you want to have an agreement with them? And you definitely do. And that's because you want to be on the same page with what the consulting fee is, how often it's paid, what are the services that are agreed to be performed, the engagement, when can you terminate it? Do you have to have a notice period? You may want that as the business for the consultant to give you some notice so you can plan before they terminate the engagement. You also want to make it very clear that they acknowledge and understand they are not employees, and therefore they are liable for taxes associated with their work. And ideally, you would also get an indemnification agreement whereby they would indemnify the company for any tax disputes down the road. Finally, interns, we're back to interns, and they are temporary employees. So yes, you definitely want to get an employment agreement with interns as well. And it's going to have a lot of the features of an employment agreement. It'll be pared down quite a bit, but at the end of the day, you want an acknowledgement in there that the interns understand that this is temporary employment and the internship is not a promise of future employment. So with our classification analysis complete, and we have our documents down so that we're prepared for dealing with all the workers, but also dealing with any acquisition down the road or deal, the question then becomes, should we get HR? It seems like we have all of our ducks in a row. And the answer is you definitely should. I think we all are so familiar with how employment issues have become top of mind on a day-to-day basis. In the past year, we've been incredibly busy dealing with employers who, with coronavirus, had people going completely remote. Maybe it was the first time that ever happened. We needed to advise on telework policies, performance management in a remote world, and then also how to deal with coming back to the office, mandatory vaccination policies, should we have them or not, and reasonable accommodations. What do you do if someone asks for that? These are all very detailed, important questions, which invoke a variety of laws and considerations that are super specialized in the HR and employment realm. So having someone who's an expert, whether or not that's someone on your team who has some HR background, an HR specialist or legal counsel, it's definitely important to have someone that you can just either go down the hall and talk to or call up. And not only are they going to help you navigate those tricky issues, but they're also going to help you management developments in employment law. And in the past year and a half here in Maine, we had a new law, earned paid leave, come into effect. That affects employers that have 10 or more employees in the state. And it's important to know, first of all, you have to advise employees of their rights, but you need to have policies in place and you need to allow employees to take that leave. So it's important to have someone who can watch out for those developments and bring the business up to speed. So of course, the business folks can focus on the business, pushing it forward and not be distracted by HR issues when they come up. Finally, related to that, not only are they going to advise when certain laws come into effect and bring you into compliance, they're also going to let you know as you grow the business, what new laws apply to you. So for example, I just said that earned paid leave, that applies when you have 10 or more employees. Means Family Medical Leave Act applies when you have 15 or more employees. And there's other certain federal and state laws that will kick in as you meet certain employee thresholds. So really important to have someone who understands the legal landscape with employment law and can advise when you should be watching out for these new laws and when they apply to you. So with that, I will turn this over to Becca, who's going to walk through policies you should think about, notices, posters, and build a little bit more on the HR aspects.
I'm going to just toss one question, if I
Please.
could. This was really helpful. What if, given that remote working, telework is becoming more of an option, let's say you have a high performing employee and they decide, you know what, I'm going to live in Florida for 6 months, a year. I want to keep working for you, but I'm going to work remotely from Florida or wherever it might be. Costa Rica would be nice, right? As an employer, do you have to be concerned about the laws there, or are they still, do they still fall under Maine law because you're based in Maine?
It's a great question, and you definitely want to be concerned with that. There's a variety of issues that go into that. That question brings up. So you have what laws apply, because sometimes it's how many employees you have in that jurisdiction. It's how long they're present and working in that jurisdiction. So it depends, but you could have issues for sure. Also, you have tax questions. What do you do? How do you pay tax in Costa Rica now or Florida because they've been working there for 6 months? So it's a great question. It depends, but it raises all of those issues.
Great, thank you. Thank you.
Well, hi, everyone. I'm Rebecca LaPierre, and I am actually going to talk a little bit about teleworking policies as part of the end of this presentation as well. So I just want to quickly introduce myself. As Katie said, I work with her in our labor and employment department. I generally practice out of our Bangor office, and I'm more than happy to help with any employment related issues that you may have. We also do immigration for employers who are bringing in employees from out of the country, and also do, union and labor negotiations as well. So for most small businesses, that's not really going to come into play necessarily, but if it does, you can always reach out to us. So I'm going to talk to you a little bit about some of the requirements that businesses have with regard to employee notices, handbooks, posters, things like that will come into play even for a very small business or a new startup. Some of these things will not become relevant until you do have more of an employee pool, but they're good to be aware of and know that they are on the horizon as you are building your employee base. So first of all, notices and posters, you need to deliver them or post them, and post them sometimes. Even if you have folks who are working out of the office remotely, you need to have either some sort of an intranet or email system, depending on the poster. There may be different requirements. In the state, we have certain required notices and posters that have to be posted for employers with, in a place where workers can see them. Some have requirements that applicants who are coming to interview also need to be able to see them. All of these posters are available on the maine.gov website. You can print them out. You don't have to reinvent the wheel to create them yourselves. So some of the ones that are required are going to be your minimum wage poster, sexual harassment posters, whistleblower protection posters, workers' compensation. That's just a handful of what will be required. There's also some federally required posters, so like equal opportunity in the Fair Labor Standards Act. So those are a few things. Sorry, Nick, can you just go back one? Sorry. So those are a few of the posters that you will be required. Some are also optional. Optional posters are going to be like the Maine Human Rights Act poster or a nursing mother's poster. But we do recommend that you have those and have a way to communicate those notices to your employees. There's also certain training requirements. If you get to a point where you have 15 or more employees, you have to actually conduct sexual harassment training. And whether or not you have 15 or more employees, employers are required to provide employees with annual notices regarding sexual harassment and what it means. We usually recommend including that in the handbook. So the next topic would be employee handbooks. Do you need one? Probably, yeah. You don't necessarily have to have one, but it's a good idea. Maine does require certain policies, like I said, like sexual harassment, to be provided to employees. And so the easiest way to make sure that you are distributing those policies and making sure that employees are aware of it is to have one comprehensive handbook that includes all of your required employment policies and the employment policies that pertain to your business, and to make sure that you have that available to your employees. We usually recommend that you have them review it, sign it to acknowledge that they've received it, that they understood it, but also make clear that this handbook is not a contract for employment. Particularly if you have at-will employees, you want to be very clear that this handbook does not change their employment status as an at-will employee. It is not a contract for employment. They're just acknowledging that they've received and understood the business's policies. The other thing you want to keep in mind when you're doing a handbook is that you want to make sure it reflects reality, not just your ideals. A lot of businesses, they want to make policies that are like, these are the dreams that we have of what we want to do, but don't reflect what they're actually doing in practice. And that can result in some liability for the business, because if you're not adhering to your own policies, it's good evidence for an employee to claim that they're being discriminated against because you didn't apply your policies consistently the way you said you were. So good policies are going to be enforced consistently and are going to be your best defense against, initial employee claims. Make sure you have those policies, make sure your employees understand them, make sure that you're following them correctly and evenly, consistently with all of your employees. Now we can go to the next one, Nate. Thanks. So I can see why Nate skipped ahead. As I said, the posters are on maine.gov. There is a link here that you can use to get the posters. As I mentioned, these are some of the required policies that we would typically want to include or recommend, even if they're not required. Some of them are required, some of them are not, but all of them are advisable to have. When you're creating a handbook, some of the things you really want to make sure you include is an equal opportunity statement, non-discrimination, harassment, or retaliation, as well as a complaint procedure for reporting those incidents, a whistleblower policy. As Katie talked about your exempt versus non-exempt employees, you want to have a clear definition in there so that employees understand where they fall, and explain how you will handle overtime. That's another great defense against wage and hour claims, to show that you have a clear policy and that it's clear to your employees whether they are exempt or non-exempt and when and how they will receive overtime pay. The ability to offer reasonable accommodations if you have folks with disabilities or religious needs that require accommodations. That's a whole other process that you're going to want to probably consult with an attorney about, because it can get very complicated, but you do have a requirement to engage with your employees and figure out what accommodations might be possible, and if there is an accommodation that is reasonable and would not be unduly burdensome. So those are just a few of the policies that you're going to want to have. Leave policies obviously are going to be important. The new earned paid leave is very complex. So you're going to want to make sure that you have a clear policy on that. I would advise that you speak with an attorney about that as well. FMLA if it applies. And then of course, as we mentioned, teleworking policies. Go ahead. So with teleworking, you want to have a clear policy. And again, you want to be sure to follow it consistently. You want to make sure that you have an ability to track hours if you have non-exempt employees. Non-exempt employees are the ones who are going to earn overtime, and you might have a clear policy that says they're not allowed to work overtime without permission, but that doesn't mean they're not going to log into their computer after dinner and check a few emails. And if they do that, they have to be paid for that. And that could count as overtime hours. You could discipline them potentially for logging in when they weren't supposed to, but you still have to pay them. So you want to make sure that you have a clear way to confirm when they're working and when they're not working. So if a wage and hour claim comes in, you're able to confirm whether or not they were actually doing work during the time that they were saying they were working. You also want to make sure that they aren't working outside of hours and not getting paid for it, and potentially causing you some liability. There's pros and cons to teleworking. So Deb's question that she brought up was great, because one of the big concerns about teleworking is, where are the employees actually located? What tax implications could there be? What state law implications could there be? And as Katie said, it's going to be dependent on the specific situation. It's going to be dependent on how long they're there for, what they're doing there, how many employees you have there, what your agreement with them is. If you've signed on consultants or contractors or employees in other states intentionally and you don't have a clear choice of law provision in their contract, that could come into play. So there's a lot of things to consider there. You also have workers' compensation concerns. Do they have a clear workspace in their home? And if they don't, what is covered under workers' compensation while they're working remotely? Are we going to cover them for workers' comp while they're making their lunch on their lunch break? Probably don't want to have to do that, and it doesn't really make a lot of sense. So you're going to want to have a clear policy that only their workstation is part of their workers' compensation, or is covered by workers' compensation. And these are all things that would go into your teleworking policy and that you should be very clear about. You're going to want to be clear about who's paying for what, who's paying for the internet, who's providing the technology, the computers, the monitors, phone lines, things like that. These are all concerns that you're going to want to have. That said, there's also some positives to teleworking. Obviously, people like flexibility. So you might have a greater talent pool to choose from. You'll have less overhead costs because you're not necessarily paying for so much office space. but that also comes with less control, less ability to supervise, and you lose some sense of community in your workplace. So these are all things that you need to consider, and it's going to matter what type of a business you're running as well. If a startup, it's a tech company, everyone's just coding on their computers all day, maybe teleworking makes a lot of sense. If you work in a community organization where everyone comes together as a team to create ideas and put together projects and events, maybe it's better to come together in person and have that human interaction. It's just going to depend on what your needs are. And when you're creating a policy, think about those needs, think about the potential liability, and if you're not sure, consult your attorney. So as Katie mentioned, we don't really cover benefits, she and I, but we do work with some wonderful benefits law attorneys. They gave us some tips to include in this PowerPoint slide. A lot of benefits laws aren't going to apply to a new business, a small business, unless you are immediately bringing on a lot of employees. If you have 50 or more employees, the ACA is going to kick in with healthcare requirement or health insurance requirements. COBRA is going to apply if you have 20 or more employees. And you just want to be conscious of what benefits you want to offer when you're recruiting employees, what's important to your employees. This is something that Katie and I do work on, is the earned paid leave law. That's a benefit for employees. It's not, like health insurance or retirement funds, but it is a benefit to employees, and it's going to probably attract some more employees to Maine, knowing that even a part-time employee is going to get paid time off, which isn't necessarily available in a lot of other states. So offering those things to employees is going to help you recruit more employees. It's going to help you recruit better employees. And so you're going to want to consider what you want to offer, what you can afford to offer, and how to structure that, because I will say that the benefits area of the world is a very niche area of law, and our benefits attorneys are primo. So I highly recommend contacting them if you do have questions about what benefits you should offer, when you're going to start offering those, the best way to structure those benefits, and if it's even a good idea for you at this point in your business progression. So Ed Feibel, Anna Donovan, and Jack Bjorn are all our benefits attorneys in our Portland office, and they are always available, and we're happy to put you in contact with them as well if you reach out to one of us. So I think that's the end of our actual slides. Did you have some more questions for us, Deb?
I do, and thank you. This is fantastic. Ironically, I'm working on updating our handbook. I was doing that this morning, working from home. So I took a picture of that slide. I'm going to get right back to it after this. A huge help. It's been a wonderful presentation. We definitely want to get this out and share this with every business. I think this is a question for Hannah. It has to do with, and I've seen this time and time again, where people go into business together, best friends, let's start a food truck. This is going to be awesome. And all is well until it's not well. And they decide they need to break up for whatever reason. How do you protect yourself? And is it good to have a partnership agreement, or are you protected through how you set up your entity? Again, and sometimes I've seen it happen where people go into business together, and one of the partners just decides to leave town and move and exits the business. It can create all sorts of complications. So how do you set something up initially to protect yourself and your partner should that occur?
Sorry. Wow. You'd think after a year I would have the unmute thing down. Sorry about that. Yeah, good question. Comes up every day, I'd say. So that would be in those governing documents that I had mentioned originally. So for an LLC, it'd be it's called an operating agreement or a limited liability company agreement, same thing. For a corporation, it'd be the bylaws or a shareholders agreement. Those can be two different types of agreements. And then partnership would be a partnership agreement. So we typically call that, there are buyout provisions, there are transfer restrictions, there are, voting rights, dissolution, events of dissolution. All of those things will be in those agreements. And that's something that the partners are going to want, the partners, the members, whatever you want to call your partnership, things that you want to discuss ahead of time, and will help craft in the agreement. So sometimes they might decide if someone wants to go, that the other partner can buy them out. If they can't afford to buy them out, they can seek financing to buy them out. And if that's not the case, then sometimes provisions are in place where the company has to dissolve. There might be transfer restrictions. So the person leaving might have the right to go sell to another person, and that becomes a new partner. It's really, the preference of who's involved, but it's something that we definitely put in place from the start.
Great. Thank you for taking that question.
Mhm.
I know for me, my biggest takeaway is don't try this at home. Right? If you're an employer, you're running a business, it's impossible to stay on top of employment law and benefits and everything that's changing. So use the experts right here at Eaton Peabody to help you figure it out. Because I think, Katherine, you mentioned there's nothing more stressful or distracting than when you try to do everything right, and then you find yourself in a difficult predicament with an employee. That's really hard.
Yeah, it's really hard. And I mean, just from a documentation perspective, and like say you do have a diligence with an investor or you're up for acquisition, it's just great to know that you did it right in terms of documenting, classifying from the get-go, because it can be frustrating for employers to deal with that later on down the road when they know that there's liability hanging out there, but there's not much they can do about it.
Mhm.
And the independent contractor piece was interesting because I've seen that time and time again with businesses trying to go the independent contractor route, but really there's a fine line between when they're an actual employee and an independent contractor. And that could get you in a whole boatload of trouble if you don't do that right.
That's right. That's right.
Great. This was fantastic. Thank you all so much. We have recorded this, so this will be up on our Facebook page momentarily. We will also be sharing this. If you know any business startup who would benefit from all of this great information, please share this with them. And just want to thank you all for your time this morning. And Shelley Sun behind the scenes from the chamber, and Nate Levette behind the scenes at Eaton Peabody. Thank you all so much. This was really, really good. Good information. We appreciate it.
Yeah.
Thanks, everyone.
Thank you.